custodian of the minor child, Elizabeth Calhoun. Ms. Calhoun, you are Elizabeth Calhoun, is that correct?
Yes, sir.
Okay, this is Liz on the podcast, right? Also present is Alicia Levine, mother of the minor child. Is Travis Brown present on audio?
He has not participated this morning.
All right, appears that he is not present. Good morning, Ms. Hills.
Morning, Your Honor.
The parties have conferred this morning with Ms. Pratt from the front of the court. I will share with everyone her recommendation. The court is aware there a stipulated order was recently entered where mother's parenting time would be supervised by an agency in Toledo, Ohio, a little more convenient than Monroe. Has that occurred or been taking place?
It has occurred, Your Honor. There have been 6 visits. There would have been 7, but one was canceled by the agency because of weather.
Okay. All right, the recommendation this morning, Ms. Sills, Ms. Calhoun, Ms. Levine, is that the current court order shall continue for a mother to complete some additional supervised visits with the minor child. I trust those visits are going well.
They are going well, Your Honor. Yes, so far.
Ms. Pratt, does your office receive reports from that agency?
Ms. Hill's office forwarded them, Your Honor, and I have uploaded them into OnBase.
Thank you. Thank you. It's further recommended that the parties appear backwards court to review mom's parenting time on June 5, 2024 at 1:30 p.m. And then in the interim, the parties will mediate with Ms. Pratt on May 17th at 8:30 a.m. via Zoom. That is recommendation of Sills. Is this recommendation agreeable with your client?
Yes, Your Honor, it is.
All right. Ms. Levine, do you understand the recommendation?
Yes, I do, Your Honor.
If the court adopts, it'll become an order of the court. We just continue with the existing supervised parenting time. Hopefully those things are going well and you're reestablishing your relationship with your son. And they will review this matter on June 5 at 1:30. But in the meantime, we're going to mediate with Mr. Pratt on May 17th at 8:30. Do you have any objection to the court adopting this recommendation?
No, Your Honor.
Okay. And Ms. Hills will copy, we send, will Mr. Brown participate in this mediation? Is it not necessary?
That's the hope. I'll speak with my client about that and see if we can get his involvement. I mean, it's always nice to have everyone on the same page who's involved in a child's life, but if not, then I think that we can work with Ms. LaPrade to try to get Ms. Levine and my client on the same page moving forward.
Thank you. Is Mr. Brown regularly exercising parenting time on alternating weekends?
Liz?
Yes, he is. I believe he worked last night. He told me he was going to be here, and I texted him this morning. I haven't got a response, so I think he may have worked last night, and that's why he's not here.
Okay, but he is exercising parenting time on a regular every other weekend. Is that correct?
Yes, it's not. We've had conflicts in our work schedule, so it's been at least once a month. We're trying to get our weekends back to where it's every other, and hopefully that'll happen next month.
Okay. And how often is Miss Levine having parenting time sessions? Is that every week or every other week?
It is currently every other week. The supervised visits place is trying to get availability for 2 hours. Right now, they do not have availability, so I'm only doing an hour.
Okay. And Miss Levine, you're still residing in Indiana, correct?
Fort Wayne, Indiana. That's correct,
Fort
Your
Wayne.
Honor.
Fort Wayne. Okay. How long a drive is that to Toledo?
An hour and a half.
Okay. All right. Okay. All right. If there's nothing further, the court will adopt the recommendation. Copy of this will be mailed to you, Miss Levine, and we'll see you on June 5 at 1:30. Don't forget to put in your calendar the May 17th, 8:30 mediation via Zoom with Miss Pratt.
Yes, I got it, Honor. Thank you.
All right, great. Thank you, Ms. Hills and Ms. LaPrade. That will conclude this matter. Everyone can zoom out. Have a good rest of the day.
All right.
Thank you, Your Honor.
The record of this matter is before the court on the plaintiff's motion for child support, spousal support, attorney fees, and other relief. This hearing is being conducted via Zoom. The president is Attorney Maria Zakorski, representing the plaintiff petitioner, Jessica Bonsoff. Ms. Bonsoff is present. In addition, Attorney Kirsten Niemiec is present, representing the defendant. Thomas Bonsoff and Mr. Bonsoff is present. The parties have conferred with Mr. Patrick this morning. Mr. Patrick will soon be providing the court a recommendation. course, the court is well acquainted with the history of this case. Ms. Sikorsky and Ms. Bonhoff appeared, I believe, back on October 27th, at which time proofs were taken. A reported settlement agreement was placed on the record, but Mr. Bonhoff was not present. And Ms. Bonhoff and Ms. Sikorsky were of the understanding that the settlement agreement had been reached between the parties, and apparently that fell apart. Did the parties meet with Mr. Walker on February 5, or did that not occur?
It did, Your Honor.
Excuse me, yes, it did occur, Your Honor, and we scheduled a subsequent mediation for April 18th. Some additional information needed to be gathered by Mr. Bansoff regarding whether he was going to file bankruptcy or take some other action. There were some issues that the parties needed to investigate, and so we adjourned that mediation. It is still scheduled.
Okay, I'm sorry, the date, April
18th,
18th, at what time?
8:30.
Thank you.
And my calendar says we have a pretrial with you immediately following.
As is mine.
Okay, I guess that note didn't get in the court file yet.
My notice says 10:30 a.m.
Okay, typically for the computer system, we have to put a time, but it's so we just always randomly pick 2 hours after mediation, but it's whenever, whether it's an hour or 6 hours, the court will be available to entertain that pretrial. So it doesn't have to be at 10:30. Is that correct? Is there a notice? In the interim, Ms. Patrick, is there any recommendation, or the party is going to simply mediate with Mr. Walker on April 18th at 8:30?
There is a recommendation, Your Honor. I will lead it into the court. It should be in your queue, but I can read it into the record.
Let's hang on. I'll see if I can find this. Let me refresh the computer. See why not. Right, this Patrick's recommendation this morning that party shall mediate with Mr. Walker on April 18th at 8:30 a.m. via Zoom. With respect to child support, that commencing March 1st, 2024. Defendant Mr. Bonsoff will pay child support in the amount of $3,372 for the 2 minor children of the parties. Uninsured medical expenses shall be paid as follows: 10% by the plaintiff mother, 90% by the defendant father. It's based upon a minimum of 75 overnights to the defendant father. Further recommended that the father will pay the mortgage on the marital home and plaintiff's car payment commencing March 1st, 2024. Spouse support is reserved at this time. Plaintiff's request for attorney fees is also reserved at this time. Finally, it's recommended that parties will not access bank accounts that do not have their names on them. That's a recommendation. Ms. Sikorsky, is this recommendation agreeable with your client this morning?
It is on a temporary basis. Thank you, Judge.
Thank you. Ms. Nemec, is this recommendation agreeable with your client this morning?
Yes, and also on a temporary basis.
Yes. All right. Obviously, both parties participate in the discussions this morning. Do either of you want to voir dire your respective clients?
I don't need to. Thank you, Judge.
No, thank you.
Right. We'll adopt the recommendation, and that will conclude this hearing this morning. We can zoom out. Ms. Nimka, I'd like to talk with you, Ms. Sikorsky, if your clients can zoom out.
Okay.
Thomas, go ahead and hit leave.
Yep, Jessica, you can leave. I'll give you a call when I'm done.
Okay.
For the record, this matter is before the court for a pretrial conference subsequent to the parties having engaged in mediation with Mr. Walker from the front of the court. This hearing is being conducted via Zoom. Present is Attorney Mary Sikorsky, representing the plaintiff Jessica Bonsoff, and Ms. Bonsoff appears to be present. In addition, Attorney Kirsten Nemec is present, representing the defendant Thomas Bonsoff Jr., who is also present.
Yes.
Before Mr. Walker, the parties have in fact reached their own agreement. Is that correct?
That
Yes,
is correct.
Wonderful. Who would like to place that agreement on the record?
I'm happy to, Judge. I have plaintiff.
Please, Ms. Sikorsky.
Thank you. Your Honor, as you know, the parties have 2 minor children, and the parties have agreed that they will share joint legal custody of those children. Physical custody is awarded to plaintiff mother, and defendant father shall enjoy reasonable and liberal parenting time. Child support will be $3,000 a month effective May 1st, 2024. That is straight child support. There will be no ordinary medical. There's no public assistance involved. It'll be $2,000 when one child remains. Out-of-pocket expenses will be paid through Mr. Banzoff's HSA, and if that fund gets exhausted, then the parties will share those expenses with mom paying 25% and dad paying 75%, and dad will continue to carry the healthcare coverage for those children. The parties are going to alternate the exemptions, but rather than split them with each party taking one, they've agreed that each party will be entitled to claim both children in alternating years. Mom will take even tax years and dad will take odd tax years. Additionally, there will be non-modifiable spousal support effective May 1st. That will be in the amount of $1,000 a month. That will be payable until the minor child Elijah emancipates, or either party dies, or their marital home is paid off in full. And specifically, my client's remarriage would not result in the termination of spousal support. The party's marital home is at, my client is going to keep that home. In contravention of the statute, the parties are going to continue to have joint tenancy with full rights of survivorship. My client will be responsible for making the mortgage payment and paying all the expenses of that home. If she does not, and defendant father has to make a house payment or pay some expense associated with the house, he will be credited from child support, and my client will cooperate in executing any affidavit to waive arrears or other paperwork necessary to ensure that he gets that credit. After Elijah emancipates, my client will have the option of buying out dad's equity, which will be 50% of the total value of the house, or the house will be sold and the equity will be shared. The parties will figure out what the value of the house is by getting a market analysis, and that will be done by an agreed upon realtor. My client does not have any retirement, but Mr. Banzoff does. My client will be entitled to 50% of his retirements from the inception of the retirement account through June 30 of 2023. That is the date that this action was filed. She will be awarded survivor benefits. The parties will share any fees or costs by attorney Ann Pastrana, who will prepare the quadros, or by any plan administrator. They will share those fees equally. The parties have some marital debt, and that includes tax liabilities from 2020 and 2021. The amounts that are owed to the state of Michigan, Mr. Banzoff will pay in full. There is $67,316.54 owed to the federal government. The parties are sharing that obligation equally by having my client's half of that amount, which is $33,650.27, deducted from the retirement account, specifically the NEAP retirement account, and then Mr. Banzoff will be responsible for the full balance to the IRS. Similarly, there are 3 loans in Mr. Banzoff's name that amount to about $9,000, and my client will contribute her half, or $4,500, by having that deducted from the NEAP retirement account, and then he will be responsible for repaying those loans. So the objective here is that she is participating with her half by taking a reduction in retirement. With respect to the 2022 and 2023 returns, the parties will file 2022 married filing jointly, and Mr. Banzoff will be responsible for any resulting liability. They will file their 2023 separately, but because it's an odd number tax year, Mr. Banzoff will be entitled to claim both children, and then they'll both be responsible for any resulting liability, or they get to claim any resulting refund. They have divided their personal property, except for that Mr. Banzoff needs to get his power tools and his birth certificate. They'll otherwise keep their personal property in their respective possessions. My client is awarded the Cadillac, the Saturn, the Corvette. There are 3 payments remaining on the Cadillac, and she's responsible for those. Mr. Banzoff is awarded his 2015 Volkswagen Passat, and if there are any liabilities associated with that vehicle, they are his and his alone. There is a land contract for a parcel of property located at 9. Mr. Banzoff is the only person on that contract, and regardless, that is his liability. And to the extent that it's an asset or has any equity, that is his as well. It is awarded outright to him. And if my client needs to assign any interest, she will cooperate and do so, and we can prepare an assignment of interest. They have a joint account at Wood Forest Bank that was closed. Right now it's negative $6 due to a monthly fee. They'll each keep their own bank accounts. My client may have her prior name of Hirschberger restored if she chooses, and we will have the standard life insurance provision. I believe that's the party's entire agreement, and I applaud Mr. Walker for his work this morning. It was a tough case.
Thank you, Ms. Sikorsky. And Ms. Nimick, did Mr. Sikorsky accurately state your client's agreement?
I have just a couple of additions and they may have been stated and I might have just missed them. But with regard to the tax exemptions, I didn't hear that when there's only one child left, that they were going to rotate them, still according to Mr. Banzoff taking odd tax years and Ms. Banzoff taking even tax years. And then I also didn't hear with regard to the marital home, that if Ms. Banzoff cannot or chooses not to buy Mr. Banzoff out of that home at the point that Elijah has emancipated, that the agreement would be that they list it for sale and they split those proceeds equally. Other than that, I think everything was covered, and I also applaud Mr. Walker and appreciate the very hard work he put in this morning.
Thank you, Ms. Nimick. Mr. Sikorsky, can you respond to those two issues?
Yeah, I thought the single exemption was implied, and I did state that the house would be sold and the proceeds shared equally. So I have no objection to either thing that she said.
Thank you. Do we need to clarify what we mean by emancipation of Elijah? Is that when he turns 18 and graduates from high school?
Whichever is later, the way it's defined by the child support formula in the statute.
Okay. All right, just wanted to clarify that.
Yes, thank you. I'll include that in the judgment.
Thank you, Ms. Sikorsky. All right, Ms. Sikorsky, you can begin with Ms. Jessica, please.
Thank you. Could you please state your name for the record, Jessica?
Jessica Banzoff?
Remember signing a complaint for divorce?
Yes.
Did you read it before you signed it?
Yes.
Were the facts that you stated true?
Yes.
And in fact, you have been a resident of the county of Monroe in the state of Michigan for 180 days, correct?
Correct. Yes.
You and Mr. Banzoff have 2 minor children?
Yes.
And are you pregnant?
No.
You heard the agreement that I placed on the record and that you worked out with Mr. Walker?
Yes.
Do you understand it?
I do.
Do you believe that the custody and parenting time are in your children's best interests?
I do.
And you understand that the judge would have heard this matter. He would have held a trial if we had asked him to, and he could have decided things very differently.
I understand.
Okay. And if the judge accepts this agreement today, you're waiving your right to that trial. You understand that?
I understand.
You understand that we've agreed on $3,000 in child support, and that may or may not be correct under the Michigan child support formula. You understand?
Yes.
And you understand that child support is modifiable if there is a change in circumstance. If you make more money, if Mr. Banzoff makes less money, either one of you can petition the court and ask for a modification in child support. You understand?
I understand.
But conversely, the spousal support is non-modifiable. The judge could have awarded you more spousal support. We've pleaded that you have some circumstances that would result in a spousal support award, but you believe that $1,000 is fair and you're willing to settle for that today.
I understand.
You understand all the property provisions and you believe them to be fair and equitable.
Yes.
You understand that if the judge accepts this agreement today, it's binding and we can't ask the judge to change any of those settlement provisions.
I understand.
Have you disclosed all of your assets?
I have.
And you and Mr. Banzoff have had a full and frank conversation about what to do with your family and your property. Is that true?
That's true. Yes.
Do you have any questions of me?
No.
Thank you. I have no further questions of my client, Your Honor.
Ms. Sikorsky, we previously took the proofs back in October of 2023. Can you simply confirm with Ms. Banzoff that she's not now pregnant?
You are stating affirmatively that you are not pregnant today, Jessica?
I am not pregnant.
Thank you.
Ms. Nimick, do you have any questions of Ms. Banzoff first?
Only one. I heard that she was asked whether she had disclosed all of her assets. My only remaining question would be whether or not all of her liabilities have been disclosed. So, Ms. Banzoff, have you disclosed all of your liabilities?
To my knowledge, yes.
Okay. I have nothing further, Your Honor.
Thank you, Ms. Nimick. Questions for Mr. Banzoff, please?
Thomas, can you state your name for the record?
Thomas William Banzoff Jr.
Okay. And you've heard the agreement as it was placed on the record by Ms. Zagorski, correct?
Yes.
Did you understand it?
Yes.
Okay. Do you have any questions about it as you sit here today?
No.
Have you had time to think about it?
Yes.
Have you had time to discuss it with me?
Yes.
Is anyone forcing you or coercing you, offering you anything to enter into this agreement?
No.
Okay. With regard to the agreement related to the children, do you believe that that agreement regarding sole custody and reasonable and liberal parenting time is in the children's best interest?
Yes.
Do you also understand that when parenting time is reasonable and liberal, there's not a schedule that the court can enforce?
Yes.
And that parenting time would be as you and Ms. Banzoff agree?
Yes.
And that if you wanted to change that, you would have to file a motion with the court?
Yes.
Do you also understand that by placing the agreement on the record today, all of the provisions regarding property are now binding?
Yes.
So you understand that means you can't come back tomorrow or next year or 5 years from now and ask the judge to make a change to the provisions regarding the property?
Yes.
You can't ever come back and ask for spousal support to be awarded to you?
Yes.
Okay. And you understand that the spousal support that you've agreed to pay Ms. Banzoff is non-modifiable?
Yes.
So that means you can't ever ask the court, even if you have a good reason, to change that?
Yes.
You understand that you had some very substantial arguments against Ms. Banzoff being awarded any spousal support, but you're choosing not to make those arguments and instead enter into this agreement?
Yes.
You also understand that if this matter had been taken to trial, the outcome could have been different?
Yes.
But you're choosing not to take that to trial, and instead you're asking the court to take the agreement that was read into the record by Ms. Zagorski and turn it into an order of the court, correct?
Yes.
Okay. You also know that in the course of these proceedings, you've been entitled to conduct what's called discovery, meaning sending subpoenas and interrogatories.
Yes.
And that by entering this agreement, you are no longer entitled to conduct further discovery.
Yes.
And you understand that there is further discovery out there, questions that you don't have the answers to that might have changed how you proceeded today, but you're not interested in getting those answers, correct?
Correct.
Okay. Have you disclosed all of your assets and liabilities to Ms. Banzoff?
Yes.
Okay. And are you satisfied with my representation?
100%.
I have nothing further, Your Honor.
Thank you, Ms. Nimick. Ms. Zagorski, do you have any questions of Mr. Bonzoff?
I do not. Thank you.
And you'll prepare the judgment, Ms. Zagorski?
I will.
Very well, the court would like to thank and acknowledge Mr. Walker for his fine assistance in helping facilitate resolution this morning, as well as, of course, attorneys Zagorski and Nimick. And the court would applaud you, Mrs. Bonzoff. Without question, the best resolution of matters of this nature is one in which you both participate, as you have this morning, ultimately agreed upon, as opposed to simply throwing things up in the air and have this court sort through them and decide them. So I applaud you for that. Based, however, on the testimony that's been presented this morning, as well as previously, as well as plain filed this case, court finds that jurisdiction has been established and that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed, and there appears to be no reasonable likelihood that the marriage can be preserved. Calling upon receipt of the approved judgment, the court will sign that judgment, and at that time, the court will order that the marriage between the parties be dissolved, and judgment shall enter, granting a divorce from bonds of matrimony. Good luck to both of you. Thank you again, Ms. Zagorski and Ms. Nimick.
Your Honor, I'm sorry to interrupt,
Yes.
but I believe there was one other matter. There was a PPO in place. That it was my understanding there was going to be a motion to dismiss made with regard to that PPO.
Will it be a stipulated order?
We can do that via stipulated order.
Judge, if I may, that order was entered on April 25th of 2023. It's going to die a natural death next week. I don't even think Mr. Banzoff's going to be in the state of Michigan. It's case number 23-146309-PP. And if Ms. Nemick wants to present me with an order terminating it, I will sign that.
Okay, that addresses that. Okay, thank you again, Ms. Zagorski and Ms. Nimick.
Thank you, Judge.
The response, I've been served by two very capable family law practitioners. So or somebody wants to make note of that. All right,
Thank you,
you can
Judge.
all zoom out. Have a good rest of the day.
Thank you, Your Honor.
Thank you.
Welcome.
Thomas, you can go ahead and hit leave. Hit leave.
Thank you.
Jessica, you can too. Hit leave.
Versus Marcellus Hutchins.
Are you Marcellus Hutchins?
Yes, Your Honor.
Good morning. Can you please state your name and your current address for the record, Mr. Hutchins?
Marcellus Hutchins.
Thank you. For the record, Mr. Hutchins has been brought before the court for possible contempt proceedings. Also present for the Zoom hearing is the Monroe County Front Court Attorney Rebecca Hicks. Good morning, Ms. Hicks.
Morning, Your Honor.
You're asking the court to hold Mr. Hutchins in contempt for failure to pay support. Is that correct?
Actually, Your Honor, I'm asking the court to sentence him. He has findings of contempt on all 4 of his cases. He has a 23-day balance on 3 of them and a 25-day balance on 1 of the cases.
Okay.
We've not received payment from Mr. Hutchins since June of 2023, Your Honor.
Whoa. And there's outstanding arrears on all 4 of these cases. Is that correct?
Yes, and current support obligations. If you total up his current monthly support obligation in total, it's $1,163 per month if you add all 4 together.
Right. Mr. Hutchins, I'm sure the court's discussed this with you last time you were before the court when the court found you contempt. You got to be proactive. If you can't afford the support, you need to file a motion to reduce your support. You can't sit on your hands. This is clicking along at $1,100 every month.
I have been searching, Your Honor, and right after I got off the phone with Ms. Hicks this morning, I got a call from McDonald's for an interview tomorrow at 1:30.
Well, you're gonna have to do that. You're gonna have to postpone that appointment, Mr. Hutchins. All right, Mr. Hutchins, the court's gonna order you personally appear in this court on Friday.
All right.
And if you want to avoid a jail sentence, then you need to be prepared to pay a total of $1,000 that morning. That's $250 for each of these 4 cases. And if you could pay the $1,000, then the court would look favorably and then would most likely continue this matter and avoid that immediate jail. So keep you that appointment tomorrow. You need to personally appear Bronx Court on the 4th floor. Bring $1,000 for your toothbrush, Mr. Hutchins. Reach out to family and friends. You can pay them back, but you've been obviously you've not been proactive. And the front of the court has a 4-page list of employers that are discriminating for employees. I can get you a job today, Mr. Hutchins. You're being too choosy. If you fail to appear on Friday at 11:15 personally outside my courtroom, the court's going to issue a bench warrant and I'll hold you contempt. You're going to allow me to add additional time to the 23 days that you already got hanging over your head. So we'd be your best interest served by appearing on Friday at 11:15. And again, reach out to family and friends, get that $1,000 together in cash to pay to the front of the court before you come up here. Any questions?
No, sir. I sure will try.
All right. We'll see you on Friday morning.
All right.
Okay, you can zoom out.
All right.
The court before Mr. Hutchins has not appeared. And do you want to, which case do you want called first, Ms. Hicks?
It doesn't matter, Your Honor. I do have several cleanup matters, or you can call Mr. Hutchins' cases.
For the record, Mr. Hutchins was ordered to personally appear today at 11:15. It's now 11:35 p.m. Mr. Hutchins has not appeared. He's not contacted the court. He was previously found in contempt. He was ordered to appear today to face contempt sentencing or pay something towards his arrears. Ms. Hicks, has he paid anything in child support since he was last here?
He has not, Your Honor. When I just checked his court case, it still shows that the last payment we've received was from June 6th of 2023.
All right, based upon the failure of Mr. Hutchins to appear or contact the court, so we'll issue a bench warrant for his arrest in all 4 cases. Bond amount of $1,000 cash in each of the 4 cases due to the significant outstanding arrears.
Thank you, Your Honor. I'll prepare those orders and upload them to your queue.
Thank you. Are you Brian Sloan?
Yes.
All right, for the record, Mr. Sloan is appearing via Zoom this morning. Also present is Monroe County Front of the Court Attorney Rebecca Hicks. Mr. Sloan, can you please state your name and current address for the record?
Ryan Sloan.
Thank you. Ms. Hicks, you're asking the court to hold Mr. Sloan in contempt for failure to pay child support, presumably?
Yes, that is correct, Your Honor.
All right, can you provide the court with a little information on each of these two cases, please?
Certainly, Your Honor. The 2014 case has a current monthly support obligation of $50 per month. The balance as of today is $1,793.23. The 2013 case is now an arrears only case. That balance is $3,437.04. Mr. Sloan was last on our show cause on February 13th. This was adjourned 4 weeks with very explicit instructions for him of what needed to be paid and how, in which file it needed to be paid on. When he appeared today with Miss Brower, he did not make those payments. He only claimed he could come up with about $50, which is current support on one of his cases this week, despite the fact that he said on average, he brings in at least $500 in his commission per week. So he's been making that money since we were here 4 weeks ago and has not been making payments. So at this time, we were requesting that he be held in contempt.
Thank you. Mr. Sloan, do you understand if the court holds you in contempt of court, you could be ordered to serve up to 45 days in jail? Since there's a possibility of jail, a real possibility of jail, you have the right to an attorney. If you're unable to afford an attorney, the court will appoint an attorney to represent you at public expense. Do you understand all of that?
Yes.
Are you asking for a court-appointed lawyer?
If possible, yes.
Well, yes, I will grant that because there's a real distinct possibility you can go to jail. Why don't you give me a cell number that attorney can reach you at?
734.
Ross Street, or do you rent?
What was that?
Do you own this home on Rosser Street or do you rent?
I rent.
Are you single or married?
Single.
With whom are you employed?
S&S Automotive.
How long have you worked for S&S Automotive?
About 4 years.
Are you, do you get a paycheck or are you paid cash?
It's cash. It's actually my family's own it.
Okay.
So
how much what's your average take home per week?
It's all base commission. Between 4 and 5 every week.
Okay. Do you do mechanical work or body work?
I mainly do the brakes and oil.
You own any property of any value, like any bank accounts?
No.
Boats, snowmobiles?
No.
Automobile?
No.
You don't have any money in any bank right now? You have,
no.
What about cash at home? You have cash at home?
No, I've got $50. I was planning on making a payment today, and then since my meeting this morning, I wasn't able to contact my lawyer or my landlord, and I can make another $75 payment on Friday. That would take that would cover up through the month of February.
That's but you have arrearages, not reducing arrearages, so that's woefully inadequate, Mr. Sloan. I will tell you that. In any event, the court's going to grant requests for an attorney. You ordered to personally appear in this court on Friday this week, 11:15 a.m. Ms. Hicks, in order to avoid immediate jail sentence, what do you recommend, Mr. Sloan?
March 15th. Can you repeat the time?
March 15th, Friday of this week.
Okay, what
Friday
time?
This week, 11:15.
11:15?
Yes, you appear outside Bronx Court. You can zoom in from out in the hallway. Your court-appointed attorney will reach you and talk with you beforehand. Ms. Hicks, what do you recommend that Mr. Sloan be prepared to pay in order to avoid possible jail sentence?
$500, Your Honor, $250 per case.
All right. So, Mr. Sloan, the court would strongly suggest that you reach out to family and friends, especially if your family wants to keep you working, and be prepared to pay $500 cash Friday morning. That is one way you can avoid immediate jail sentence. Otherwise, to bring $500 or bring your toothbrush, right?
All right. Thank you.
So Friday morning, 11:15. Again, if in fact you pay the $500, the court would most likely delay any imposition of sentence. Otherwise, And that apply, this can apply 100% towards your arrears. It's not going to fines or court costs. It's going to apply 100% to your arrears. You need to get back on track and make consistent regular payments every week, Mr. Sloan. Even the one arrears case only, you got to reduce that. Right.
When I was down in Toledo this week, they only told me for that case I only owe $2,400 on that. When I was down in Toledo, this was
okay.
Let me get
right,
the date.
Mr. Sloan, you can come in on Friday morning, talk with your friendly court caseworker. They can give you, you can ask for an audit. They can give you printouts. Whether it's 2,400 or 3,400, you got significant arrearages. You're not making regular payments. So we'll see you on Friday morning, 11:15. And the attorney will reach out and talk to you. We're going to give him your cell number, okay?
All right, thank you.
Anything further, Ms. Hicks?
Nothing further, Your Honor. I'll prepare these orders and upload them to your queue.
President is the court attorney, Timothy Leiter, and Monroe County Attorney Court Attorney Rebecca Hicks. Good morning, everyone.
Morning, Your Honor.
Good morning. Good morning.
Mr. Sloan is appearing via Zoom.
Yes.
Court's recollection, Mr. Sloan, you're ordered to appear in person today.
Yeah, they just said that I wrote down that I had to appear over Zoom, so that was my fault. That was my apologies.
Okay.
Had I realized that, I would have made it into court today.
Well, you're in Rosser Street, just a couple blocks away from the courthouse, correct?
Correct.
All right. Did Ms. Hicks said Mr. Sloan make a payment today?
He did, Your Honor. He made the required payment of $500, total $250 on each case.
All right. That's the main thing. His court wanted you to make a payment, Mr. Sloan. You have no objection to Mr. Sloan then appearing via Zoom then this morning, Ms. Hicks?
As long as he is going to be admitting to the finding of contempt, Your Honor. If he wants to have a hearing, then I'd rather he appear in person as court ordered.
All right. Mr. Leiter, have you had a chance to discuss these proceedings with Mr. Sloan?
Your Honor, yes, I did. Your Honor, I spoke with him this morning. I've tried to make phone calls, but apparently we had the wrong phone number for him. He did correct that, but I did talk to him. I talked to Ms. Hicks first, and she advised of a potential plea agreement. I advised my client of that. My client said that he wishes to avail himself of that plea agreement today. So I let Ms. Hicks place that on the record.
All right. Thank you, Mr. Leiter. Ms. Hicks, what would you recommend if Mr. Sloan admits to contempt this morning?
Then, Your Honor, the front of the court would not be requesting any immediate jail because he did at least make those nominal payments. The front of the court would then adjourn this over to May 14th at 10 a.m. back on my docket to monitor for consistent payments moving forward.
But you're asking the court to make a finding of contempt and reserve any jail. Is that correct?
Yes, Your Honor, that is correct.
All right. All right, Mr. Sloan, you've heard everyone make their comments this morning. Do you understand that if you admit to contempt this morning, that you're outstanding arrearages or you're not paying child support on a regular basis, the court would impose a sentence of 45 days, but because you made a payment and Ms. Hicks is recommending no immediate jail, the court would simply hold the 45 days over your head. In other words, I'd give you the key to the jail. You would not serve any time in jail unless you put yourself there by failing to appear for the next review on May 14th or failing to make any payments between now and then. Do you understand that?
Yes, Your Honor.
Right. Is that what you wish to do, is admit to contempt this morning?
Yes, Your Honor.
Thank you. Mr. Sloan, do you admit and acknowledge that you are obligated to pay child support for the maintenance and support of children born to you and Sydney Harmon, as well as to the children born to you and Brenda Casier?
Yes, Your Honor.
You admit and acknowledge that there's about $1,700 of arrearages in the case involving Sydney Harmon, and there's arrearages about $3,400 in the case involving Brenda Casier.
Yes, Your Honor.
Of course, the $500 you paid, that's going to reduce the arrearages in each case by $250. Mr. Sloan, are you currently employed?
Yes, Your Honor.
And you're employed as a mechanic for S&S Automotive Family Business, is that correct?
Yes, Your Honor.
Do you admit and acknowledge you've had recent income that you've not paid toward your child support obligation in these two cases?
Yes, Your Honor.
Do you understand that you must make monthly payments on both of these cases? And if you can't afford the amount ordered, I'm sorry, one case is arrears only, but the other case is $50 a month. You need to pay minimum of that per month. If not more, to reduce your arrearages. Do you understand that?
Yes, Your Honor.
Ms. Hicks, do you have any questions, Mr. Sloan?
I have no additional questions. Thank you, Your Honor.
Right. Mr. Leiter, do you have any questions, Mr. Sloan?
Your Honor, I do. I guess it's somewhat ancillary, but Mr. Sloan, just for the record, what are the first three digits of your phone number?
734.
No, okay, go ahead.
734.
Okay. I just wanted you to get that, just so we reflect that the record's correct. If they need to get you, if the front of the court office needs to get you, the first three is 430, not 440.
Yeah,
Right, thank you, Mr. Leiter.
I've made that mistake many times.
No
Thank you,
problem, Your
Victor.
Honor. It's, my client admitted that it was a mistake on his part, non-deliberate. So I have no
No
further
problem.
questions.
Thanks for clarifying that, but Mr. Sloan, perhaps more important than your phone number is keep the front of the court informed of any change of address. If you move this Ross Street address, you need to notify the front of the court in writing. In any event, based on the testimony that's been presented this morning, on part of Mr. Sloan, the court finds that sport orders exist in both cases. There are arrears in both cases. They lack a due diligence on the part of Mr. Sloan in minimizing those arrears and paying regular sport is the basis for contempt. The court will accordingly find Mr. Sloan being in contempt of court, but the court will follow Ms. Six's recommendation. Anything further this morning, Mr. Leiter?
No, nothing further, Your Honor. We do thank the court as well as Ms. Hicks.
Thank you. Mr. Sloan, anything you want to say before the court opposes the sentence?
No.
All right, Mr. Sloan, the court's already served 45 days in Rogue County Jail with that, and then and each of these two files, but that the sentence is reserved. So you will not serve any time unless you ignore these obligations. You are the ordered to appear before Ms. Hicks. You can appear via Zoom on May 14th, 2024 at 10 a.m. for review.
All right.
So it's critical you appear on that date, and you need to make payments between now and then. If you don't make any payments in the month of April, she's going to bring you right before this court. And then she's bringing before this court. That's because she wants you to serve some time in jail. So you can avoid this, Mr. Sloan, by getting on board.
Yes, Your Honor.
Take care of this obligation. And with respect to the arrears only case, Brenda Kaiser, Ms. Hicks, there is no monthly obligation due in that file, correct?
That is correct, Your Honor. However, Mr. Sloan must make payment every single month on that file as well.
Okay, do you understand, Mr. Sloan? So you got to pay more than $50 every month. It's pretty nominal. You say you're taking home $400 a month or per week. You need to take care of this obligation. All right. If there's nothing further, I'll conclude this matter. You'll be mailed a notice that Mr. Sloan to appear on May 14th and before Ms. Hicks. Now concludes here, and you can all zoom out.
All right. Thank you.
Thank you, Your Honor.
Now session
Thank you, Your Honor.
page 2, Eric Vaught versus Crystal Vaught.
For the record, this matter is before the court for the purpose of reviewing parenting time as well as the motion of Attorney Kenneth Berger and John Danielski to withdraw his attorney of record for the defendant, Mother Crystal Vaught. This hearing is being conducted via Zoom. Present is Eric Vaught as well as Crystal Vaught and Attorney John Danielski on behalf of Ken Berger. Good afternoon, everyone.
Hello, John.
Parties have conferred with Mr. Walker for the front of the court this afternoon. Recommendation is as follows. Follower shall continue to have parenting time every other Sunday from 9 a.m. to Saturdays at 9 a.m. to Sundays at 5 p.m. That continues the order of January 16th. Father and the minor child noted has their first therapy session together today. All parenting time exchanges shall be at the Sunoco gas station. Of course, I believe that exit is currently closed, so the parties can find an alternative way to get to that location. Further, that the parties appear back before court to review parenting time April 30th, 2024 at 2:30 p.m. And of course, that will be via Zoom. That's the recommendation. Mr. Danielski, does your office intend to continue representing Ms. Vaught, or are you asking to be relieved today as her attorney?
Well, a couple things. As to the rec, Crystal had indicated to our office she was going to handle it on her own. So if she's okay with it, obviously we're okay with it. It's no disparagement on Crystal. She's been a great client over the years. I think at this point, though, she, she feels that she can handle it on her own, and no point in racking up more attorney's fees. It's really a financial thing, Your Honor. We're very busy, and so we're asking to be let go in this case. And Crystal can always call us if she needs our help.
All right. We'll start with you, Ms. Vaught. Do you have any objection to Mr. Berger and or Mr. Danielski withdrawing as your attorney of record?
Oh, no, sir. They've been great.
Okay. All right. The court will permit that. Mr. Danielski, you will submit an order to that effect?
Yes, Your Honor.
Okay. And we should show Mr. Walker's recommendation that Mr. Danielski is in fact appearing. Mr. Berger works for Mr. Danielski. I suppose it's showing that attorney was not present, but maybe we could just add a sentence to it that the office of John Danielski is permitted to withdraw his attorneys of record for a misfought. Maybe that would cover it. Then Mr. Danielski does not need to incur the time of preparing a separate order, if that's possible. And Ms. Vaught, you understand this recommendation to have no objection to the court adopting it. Is that correct?
Yes, sir.
All right, Mr. Vaught, do you understand the recommendation?
Yes, Your Honor.
Do you have any objection to the court adopting this recommendation?
The recommendation for,
Do you have it? First of all, do you understand the recommendation? You indicated yes. The second question is, do you have any objection to the court adopting this recommendation?
no, sorry, I didn't understand you. I'm sorry.
Okay. Do you have an idea what these therapy sessions, will they be every other week? Do you know at this point in time?
Tonight is our first one, and it's at 6, Your Honor.
Correct. I'm aware of that. Do you know how often they will be? Once a month? Every other
Not
week?
yet. We won't know until we go and talk to the lady tonight, sir.
Okay. Well, I hope those go well. Those are critical. Hopefully when we come back on April 30th, we've got some good sessions and perhaps get a positive letter from the counselor and we can expand parenting time.
Yes, Your Honor.
All right. Do either of you have any questions for the court? Ms. Vaught or Mr. Vaught?
No.
Okay, wonderful. All right, again, we'll review this on April 30th, 2:30 via Zoom. Keep the court Zoom ID number. Copies to be mailed to each of you. And Mr. Walker, you just asked sentence that the office of Attorney John Janowski is permitted to withdraw as the attorney's of record for the defendant, Crystal Vaught. All right, that will conclude. Everyone can zoom out. Have a good rest of the afternoon.
Thank you, Your Honor.
Thank you, sir.
You're welcome.
Page 3, Eric Vaught versus Crystal Vaught.
For the record, this matter is before the court for the purpose of reviewing plaintiff father's parenting time. This hearing is being conducted via Zoom. The present is plaintiff father Eric Vaught, and also defendant mother Crystal Vaught is also present. Good afternoon, both of you.
Good afternoon.
Good afternoon.
The two of you have conferred with Ms. Pratt from the front of the court this afternoon, who's provided the court the following recommendation. It does appear to modify some terms of prior agreements. The recommendation that follows should have parenting time every other weekend. Fridays at 6 p.m. until Sunday at 5 p.m. The parties will meet at the Pleasance, presumably at, not sure, there's a gas station there, number of cannabis operations, perhaps the gas station might be the best.
Yeah, we do the gas station, sir.
Yes.
The gas station with the Taco Bell there?
Yes.
Yes, Your Honor.
Okay, that's, okay, so parties will meet there to exchange at Fridays at 6, Sundays at 5, alternate weekends until the Luna Pier construction is complete. Shall have 3 weeks of summer vacation with minor child, 1 week in June, 1 week in July, 1 week in August will be taken with Father's Weekend. It will not be the week prior to the beginning of school year.
Excuse me, sir.
Yes, that's recommendation.
On the Sunday, no, on the Sunday, I thought Eric and I agreed to 6 p.m. Was that correct, Eric? Not 5?
I thought it was 6 as well. I thought it was 6 to 6.
Yeah,
Okay.
I had it written down. I'm sorry. Did I?
Oh, it's okay. You guys had originally told me 5, so I just stayed consistent.
Oh.
I changed it to 6.
Yeah, it
That
was
the
changed
request.
to 5, but we had 6 before. I'm being honest.
Fine.
Yeah.
That might be easier to remember. Friday at 6 to Sunday at 6. So Mr. Pratt, we can modify that to make it Friday at 6 to Sunday at 6. You both agree to that.
Thank you, Your Honor.
Thank you.
And you both can agree upon which weeks in those months, correct?
Yes.
He has this weekend coming, sir, so we would just like to move it forward.
Wonderful. Okay. All right. Do either of you have any questions for the court?
No.
So it'll be effective this Friday, correct, sir? He'll get Friday at 6.
Well, do you both agree with that? You know what's best for your respective schedules and that of your child.
Yes, I'd love to have them.
Is that okay? It's okay, Eric.
Absolutely.
Definitely.
I mean,
Okay.
it's certainly okay with this court if the two of you as parents agree. So yeah, so they'll start to based on you're both on the same page, which is wonderful. And please communicate if there's sometimes, as you know, there's construction on 75. So if it's backed up, just to let the other text other person know you're running a little late.
We've had to do that.
So please communicate.
Yes, sir.
All
Yes, sir. We've
right,
done
do
that.
you any other questions for the court or for Mr. Pratt?
No.
Okay, all right, let's start this week and then Friday at 6 to Sunday at 6 and the meeting at Pleasance at the gas station where the Taco Bell is. All right, there's no need for another review, so that's wonderful. If in fact problems exist, either side can petition the court for modification of this schedule, but hopefully it'll work. And
For
of course,
clarification,
you
I'm
can always
sorry.
agree upon other parenting time, as you can agree. And this does not prohibit other parenting time. If dad wants to take his son to dinner or something, or during the week, especially there should be more flexibility during the summer. So we'll work together.
We've
Yes,
done
sir.
that in the past, sir, for birthdays and stuff. But I do have a quick question in regards to the clarification. No less than at least 2 weeks. No less than that. But as soon as possible would be better, because
Sure.
that way I can coordinate properly.
Okay.
We need to put that in writing, minimum of 2 weeks advance notice. Or is that hamstring Mr. Vaught? Why do you okay with that? We put-
I don't have a problem with the 2 weeks.
All right, we'll just try to minimize issues. We'll put in
Yeah,
there that.
I'll make it as early as possible.
Okay,
Thank you.
we'll just say minimum, there'll be a minimum of 2 weeks notice provided of your intended week during
Yes, sir.
those months.
Yes, Your Honor.
You'd add one just sends at the end of that, just fellow shall provide a minimum of 2 weeks advance notice of his intended summer parenting time.
Yes, sir.
And I presume you previously adopted Friends Court holiday schedule. For example, like dad always had his Father's Day, mother always had his Mother's Day, and so forth.
Yes.
Yes, definitely.
All right, we're gonna just add one sentence, so minimum of 2 weeks advance notice. So as soon as you know your schedule, Mr. Vaught, your work schedule, provide that notice to Ms. Vaught. So
Definitely.
plan for it. All right, wonderful. The court applauds you for reaching your own agreement. It's wonderful. And the court will adopt that agreement. You will both be able to copy of this. And that will conclude this hearing. You can both zoom out. Have a good rest of the day.
All right. Thank you, Your Honor.
Thank you,
You're
Ms.
welcome.
LaPred.
Thank
Thank you,
you.
Ms. LaPred.
Sarah?
Bye-bye. Thank you.
For the record, this matter is before the court on the plaintiff's motion for custody and or possession of the minor children of the parties. Just wanted to make sure there was one child or more than one child, but the minor children of the parties. This hearing is being conducted via Zoom. This court did enter an ex parte order on February 14, 2024, which awarded the plaintiff father possession of minor children, and that mother's parenting time be supervised. And schedules matter for review on this date. The allegations of Mr. Griffin, the plaintiff who's present with his attorney, Alexis Spencer, this afternoon for this Zoom hearing, is that the defendant mother is currently inpatient in a rehabilitation facility in Columbus, Ohio. Good afternoon, Mrs. Spencer.
Good afternoon, Your Honor.
The court has been informed that your office is not secured service. The court file does contain proof of service. A copy of this order was mailed to Ms. Griffin at the behavioral health facility, or Light Behavioral Health Facility in Columbus. Is she no longer there?
Your Honor, we are not entirely sure. So we planned on getting personal service. We contacted the facility and they said that that would not be able to happen because nobody is allowed to go in and obviously be back where the patients are. So then we requested if we sent certified mail to the person there, if they would be able to get that to her and have her sign the green card and send it back. They told us yes. So that's what we did. We filed the proof of service stating that we did send that. Today, right before the hearing, we got back in the mail the documents that we had sent. It was labeled as return to sender, and we are not entirely sure where she is at this point. She was at Columbus at the time that we filed this. My client has been in contact with her via email, and he has asked where she is. We have not received a response to that question, but we do know she is still in rehab somewhere.
Okay. Does Mr. Griffin have any time frame? 30 days, 60 days, 45 days, indefinite?
So originally they stated, I believe, that it was 30 days. And that's when we had filed this. But then she informed him, I believe, that it would be longer due to, you know, the severity of the relapse this time. And like I said, we do know she is still in rehab at this time. We just do not know exactly where, for how long, which is what Mr. Griffin is trying to currently find out so that we can get proper service on her.
Thank you. Has Ms. Griffin had any phone contact with the children?
Yes. As a matter of fact, last night, she called my oldest son on his phone, and she ended up talking to my oldest son and my youngest son for, I want to say 20 minutes or so.
Good, good. All right, so we'll adjourn this so we can provide you a new date, Ms. Spencer, and you can renotice it for hearing.
Okay.
How about April 30th? Soonest date we have available is April 30th. So Tuesday, either 9:30 or 2 o'clock. The court will continue the ex parte order.
Okay. I'm sorry, Your Honor. You said April 30th at 9 o'clock or 2:30?
9:30 or 2 o'clock.
We could do the 2 o'clock.
All right, if you can renotice it for April 30th at 2 p.m., please.
I will do
Of
that.
course, the ex parte order does provide that the dad will have possession of the children, and mom is awarded supervised parenting time with either the plaintiff father or the paternal grandparents. So that the terms of this order shall continue. Also prohibits the mother from operating a vehicle with the children and prohibits the mother from appearing at the children's school. All right, obviously, Mr. Griffin, obviously having permitting contact between the children and mother is best interest of the children, certainly will assist the rehabilitation of Ms. Griffin as well. So please try to allow that to happen.
Ma'am, what is your name? Ma'am, what is your name?
My name's Kaylee DeMerchant.
Okay, one moment.
I'm sorry, someone popped in that should not have been in here.
No,
all right.
Patrice had me to see if that was her.
Okay. All right. Anything further than this afternoon, Mr. Spencer?
No, thank you, Your Honor.
All right. Do we need an order that continues ex parte order? Ms. Patrick?
Up, Your Honor, if you'd like it.
Yes, it won't hurt. It won't hurt just in order that the defendant, no service upon the defendant did not appear. Ex parte order of February 14th, 2024 shall continue with a to be renoticed for April 30th at 2 p.m.
I have that, Your Honor.
Right. Anything further, Ms. Spencer?
No, thank you.
Okay. All right. That'll conclude this hearing. Everyone can zoom out. For the record, this matter
Thank you.
before the court for walk reviewing defendant mother's parenting time. This hearing is being conducted via Zoom. Present is Attorney Derek Jacques, representing the plaintiff father, Tyler Zonka. Mr. Zonka appears to be present with Mr. Jacques. In addition, the mother, Kaylee DeMerchant, appears to be present. Good afternoon, everyone.
Good afternoon.
Good afternoon. The parties have conferred with Mr. Pratt for the front of the court this afternoon. Mr. Pratt has provided the court with a fine recommendation that mother will have supervised parenting time with family counseling child services once she is released from Sacred Heart. And the parties will appear back before the court. Court's going to keep this matter on our docket so we can reestablish a relationship between mom and minor child Jack. So we'll review this matter on May 28th, 2024 at 1:30 p.m. That is recommendation. Ms. DeMerchant, do you understand the recommendation?
I understand the recommendation, and I'd like to fight against that, sir, because you knowingly I don't know how to say this. Like, I mean, I have not seen my son in 8 months. I have not touched him. I have not hugged him. The last court hearing residing just required me to go to psych evaluation. Now, I provided psych evaluation. I didn't even have to do that for Mr. Jacques, and he's all concerned about diagnoses that I've had, diagnoses that I've had for 20 some odd years. I understand that. And then he wanted to say that, oh, we're still afraid of the safety of the child. Now, Sacred Heart facility in Clearview, it is a women's facility for children. And I understand that it's court docketed at this other service down in Monroe County. However, where I reside now is Kimball Township. Now, I asked friend of the court if my son could come visit me because I haven't even touched him and I don't even remember when. And then Mr. Jacques then proceeded to say that it was an unsafe environment for a 5-year-old. Now I have my counselor, her name is Chris. What's your last name? Peltier. with me, and she can advocate for what type of facility this is. And sir, I mean, with your permission, sir, I would appreciate it if she could at least step in and explain to you where I'm at and what the facility encompasses.
Right, Mr. Burchett, the court's familiar with Sacred Heart. Will they allow a child to come in to visit?
Yes.
Yes.
Is there a common area where it's appropriate for a visitation?
Yes.
A community
Yes.
room or something of that nature?
When could I turn it over to Chris, because she can advocate further about what everything encompasses and what kind of counselors and people that are here supervising the children. Please and thank you.
The court is familiar with Sacred Heart, ma'am. I don't need an education about Sacred Heart. Do you have an expected discharge date or not?
Right now, it's kind of up in the air. Like, I mean, I can stay here, I believe, because I'm part of St. Clair County. How many extensions can I get, Chris?
Well, it's a wonderful facility, and obviously we just want you to be well because Jack is 5, and yes, you need to be part of his life. Mr.
Yeah,
Cox, is your client opposed to once a week just taking my child over there for an hour to visit with mom?
My client is opposed to that due to the nature of the facility, due to the fact that the reasons that Mr. Merchant has not seen the child in such a long period of time are caused by her own actions or inactions, not anything that we've done maliciously against her. The entire reason for these treatment programs was to ensure that she was on the right track moving forward, and we are happy that she is in this center and hopefully moving forward to be able to be brought back into their son's life. But at this point, this is a facility that's nearly 2 hours away from where my client lives. It's not been completed. There's been occasions in the past where Mr. Merchant has not successfully completed these programs. The psychiatric facility that she was in for psychiatric treatment for 10 days had concerning statements in their notes with her being discharged, saying that the patient will remain at a chronically elevated risk for harm to self and or others due to impulsivity and or substance abuse, that she had suicidal ideologies as to being admitted and while she was there. And this was from February 16th until February 26th. So these notes occurred after our last hearing even took place. So we have serious concerns moving forward, but
no, I object to that.
Mr. Merchant, don't interrupt, please.
But
yes, sir.
My client, Mr. Zonka, nonetheless wishes for there to be some development towards a relationship other than just phone calls or video chats between their son and Mr. Merchant. However, we think that Shelter Family Services is more appropriate once there's a showing that these services have been successfully completed as to the inpatient rehabilitation therapy for substance abuse that Mr. Merchant's in at this time. Once she's discharged, we're happy to start, have them supervise in the center, get reports sent to ourselves in the court, and make sure things are going smoothly, and then take it from there. But as of now, there's nothing to show that this is actually going to be completed.
Mr. Merchant, how many months have you been in Sacred Heart?
I have not been in Sacred Heart for months, but I have provided months worth of clean drug screens to Mr. Jock, which he also failed to mention. Also on my behalf.
How long, ma'am, have you been a resident of Sacred Heart?
How long? Only about 8 days, sir. Before then, I was hospitalized. Wait, hold on, sir. Before then, I was hospitalized for 10 days. And then I also got involved with community mental health services, Safe Horizon services, and as far as like, I am 8 months pregnant currently, sir. And I also got involved with adoption and outreach programs for my child and WIC. Simultaneously, it just sounds like that they want documentation of how the child is being taken care of. I also object to the suicidal ideation. Mr. Zonka knows himself, and the order was to get into psychiatric care, correct, sir? In order to get into inpatient psychiatric care, you have to say you are at risk to self. So did I want to kill myself? No, I don't. I have a safe place to go. I have a safe home up here in Kimball. However, I am stabilized on meds, and I also provided 2 months of clean drug screens. So I don't understand what the issue is, except that he does not want to drive out to Memphis, Michigan, which I understand is a long drive. But I plan to be staying here for up to, 4 to 6 weeks or whatever it is. Just one visit, sir. Why is that not acceptable when they have, childcare, people with master's degrees and doctorate degrees working at this facility, facilitating women and children reunification? How is that different than what's down in Monroe, except that he's being lazy?
All right, thank
If I
you.
could, Your Honor,
Mr. Zaka, there's no substitute for physical contact between a parent and a 5-year-old child. The only way the longer there's a separation between mother and child, the more difficult it is to reestablish this relationship. Sacred Heart, in the court's opinion, is a safe facility. Obviously, this child will not be exposed to mom who's intoxicated or out of control. And obviously, if Mr. Zaka does not wish to drive 2 hours, the court understands that. Mr. Demerchant, do you have a family member that could drive that has a decent relationship with Mr. Zaka and could drive Jack to see you once a week or every 2 weeks for an hour? Do you have someone else that you can suggest could transport him? Somebody that Jack knows. Do you have how about your mother?
Brian Burns. Brian Burns. He knows Brian Burns. Brian Burns.
Okay. Mr. Jackson, about Brian Burns, is Mr. Zaka North? This is Brian Burns that could transport Jack to see his mom for an hour.
I think one of the other issues that we didn't bring up because we weren't sure if it was necessary or not is that Jack is not currently aware, to the best of our knowledge, that Mr. Merchant is pregnant. And it was my understanding from previous conversations that she had intended to place this child up for adoption. And we have concerns about bringing him to see his very pregnant mother and being old enough to understand what's going on and then not having ever the ability to see as possible sibling. If this child is in fact going up for adoption, we think that that would be both emotionally and psychologically damaging to him at this point.
Objection.
I'm not sure if a 5-year-old can fully comprehend that. Is your client comfortable with Brian Burns? Does he know who he is?
Yes, I'm comfortable with Brian Burns.
Okay. What about Mr. Pratt? Any thoughts? If we have a response with third party, do you see any harm for this 5-year-old child having some contact with mom once every 2 weeks or something? Just some contact, just a visit. It'll have to be in the Sacred Heart facility.
Your Honor, my understanding after talking with Mr. Merchant is that in a couple weeks she's planning on being back home. So I'm not sure how quickly we could get that established with Mr. Burns.
Right. You said Mr. Merchant said you're going to be there 4 to 6 weeks.
Yeah, I don't know how St. Clair County mental health access works and how many extensions I can get. However, I know this facility is willing to work with me. Even say, sir, if I switch my mind on the adoption proceedings, they will let me bring my baby back to the facility and help me with all those other things. That's unrelated. I understand that, sir.
The court's only concerned about Jack, not concerned about
I understand.
Unborn child. We're concerned only about Jack.
Okay, yes, sir. I understand. I apologize for
Well, the court's not opposed to Mr. Burns transporting Jack to provide the parenting time takes place at Sacred Heart facility. I don't know what their hours are. They may have rules where they only allow it maybe on a Saturday or a Sunday afternoon. But are you able to reach out to Mr. Burns to see his availability, and he can perhaps communicate with Mr. Zaka?
The only availability would have to be on the weekends due to it being a nearly 4 hour plus round trip plus visitation or traffic, and it would affect his schooling at this point. So it would have to be something on a weekend.
Okay.
no objection to that.
All right. Well, the court will permit Brian Burns to transport the minor child to visit mom at Sacred Heart. What do you suggest, Ms. Pratt? Once every 2 weeks?
I would ask Mr. Merchant if they have specific family times that we could set up so that the child could visit during those times as appropriate.
Any specific time that would work better?
Well, we'll work around
For the facility, does the facility have certain, like, for example, if your sister or mother came to visit you, is there certain visiting hours?
There is no visitation, but the children are different. That's a different accommodation for them. But they do have staff 24/7 on that can provide and assist with the transport and supervision of a child and that are trained. So
Mr.
anytime I
Merchant,
work with the court.
you need to make inquiry of staff there in terms of if someone brought my son Jack to visit me, would have to be a Saturday and Sunday, and what are the time frames? Is it 1 to 4? for example, on a Saturday or Sunday, you need to, first of all, determine the timeframes that they would allow a child to visit you, a 5-year-old. Then you can contact Mr. Burns, and if Mr. Burns is willing to do that, then perhaps Mr. Burns could reach out to Mr. Zonka and try to facilitate a time that's good with Mr. Burns. So perhaps if the court just generally ordered that Mr. Burns is permitted to transport the minor child to visit mom at Sacred Heart facility at, on a weekend at times that is agreeable to that Sacred Heart facility.
Okay, 12 to 5 is what my counselor has suggested. If for some reason, Mr. Burns does go to Florida, and I did forget about that during the winter. If for some reason he is still in Florida, would my mother still be acceptable to Mr. Zonka as far as a child transport? My mother were willing to make that long trip.
Mr. Zonka indicated that he would be. Absolutely, yep.
What is your mother's name? What is your mother's
Cynthia,
name?
just in case, you know, so there's two people that are, you know, connected with, transporting my son so I can see him, and I'm sure that they will facilitate that. Okay.
All right. Well, the court would encourage that. So it's up to you, Mr. Merchant, to get the ball rolling. You need to first of all find out from the facility whether it's Saturday or Sunday, then reach out to either Mr. Burns or Miss Carlson, your mother, and have them contact Mr. Zonka to coordinate a time. Let your mother know.
Yeah. Saturday or Sunday. My counselor did advise me that they will work around whatever is admissible to the Mr. Zonka and my mother or Mr. Burns. Okay.
Okay. So the dates will have to be worked out to Mr. Zonka and your mother, or your mother or Mr. Zonka and Mr. Burns.
Okay,
Mr.
perfect.
Zonka, obviously it's important for Jack, you know, to have some contact, and even if it's just an hour. I understand it's a long drive, but you know, just you know, whatever time that person thinks appropriate, you know, whether it's 2 hours. I mean, 5-year-old's gonna, I don't know, sometimes you get bored after a couple hours, so perhaps it's a couple hours every other week. I think whatever the parties, I'll let the parties agree upon the time frame.
Thank you.
But I do think as long as you're there at that facility and the period of time would have to occur in that facility, Mr. Merchant.
Yes.
So you will contact your mom and or Mr. Burns. If Mr. Burns is unavailable, contact your mom, have your mom then contact Mr. Zonka to line up a Saturday or Sunday afternoon. Maybe a Sunday is better for Mr. Zonka, I don't know. But the two of them have to work out the schedule.
It depends on his schedule. Yes, his schedule varies. So
right.
That's fine.
So
I'm satisfied with that. Thank you, sir.
All right. So Mr. Zonka, the court's just encouraging you to try to see if you can make it work for the benefit of Jack. And obviously there's gonna be someone supervising, so it's not gonna be mom alone. There'll be someone there. Whoever it's Mr. Burns or Mr. Carlson will be there, and probably also maybe a staff member. I don't know. But obviously, if anything's there, obviously Mr. Merchant will not be intoxicated or under the influence of anything at that facility. So Ms. McPrentice can just add some general language to that effect.
Yes, sir.
To the recommendation, we'll review mom's parenting time May 28th at 1:30. Mr. Merchant, be focused on yourself right now. If you want to be a mother to Jack, you've got to take care of yourself first. So be very focused on your recovery. Don't be in a rush, because it's gonna be a lifelong thing. Even if you're outpatient, you're gonna be involved in inpatient.
Yes, and that's why
for the rest of your life.
Yeah, that's also why I understand where Mr. Zonka is coming from with dragging his feet for me to see Jack. I do understand that it's because he does care about Jack and he doesn't want this to happen again. And, you know, I mean, like, you know, next time it's the crash, it's like, you know, that might be it. And then it's like, and Jack will remember, and I don't want my son to have build up resentments against me, sir. Yes, sir. I understand. Thank you.
So you got to make sure the visit's appropriate.
Okay. Thank you so much.
And I'm sure other children visit at Sacred Heart. I do believe so. So you can maybe ask whether or not there's some games available. You can play with Jack.
There's tons of stuff to do here. Yes.
All right. So review this matter on May 28th at 1:30. Mr. Jocks, anything further?
Nothing for me. I just want to clarify that once Mr. Merchant is discharged from that facility, the parent time will pick back up at shelter services.
Correct. Yes. Once you're released, then it's got to be supervised. We want to make sure you're on the strong path, Ms. Demerch. So yes, after your release, then you want to contact this agency, Friend Couch Child Services, and schedule the intake.
I have already contacted them to be waitlisted, sir.
Okay.
I'm just waiting on the response because it was a long wait list. So probably by the time I'm out of this facility, then it'll go smoothly into that, sir. Yes.
Well, don't be, obviously, the longer you can stay there, the better, because you can develop those tools that help you later down the road, Mr. Merchant.
Yes, sir.
All right. The court appreciates the willingness of Mr. Zonka to give it a try. Then facilitate some contact to the minor child and mom. Mr. Pratt, any concerns or question about the language? I think just keep it general.
No, sir, it just states that Brian Burns or Cynthia Carlson may transport the child to Sacred Heart for visitation as agreed with father.
Okay, wonderful. Thank you.
Thank
All
you.
right, thank you, Mr. Jackson, Mr. Zonka, Mr. Merchant. That will conclude here. You can zoom out, and we will see you back for a review on May 28th at 1:30.
Thank you so much, sir.
Thank you.
That recommendation is in your queue.
Yeah, Ms. Brad, do you have an address for Sacred Heart to send a copy of this order to Mr. Merchant?
Your Honor, actually, I do because I have a fax in front of me from Sacred Heart. I'm sure we could get that information to her.
Wonderful, great. All right. Thank you, Mr. Jacks. Have a good afternoon.